Okay, we're gonna go from the top. I'm very tired, but it's gonna change our lives. Okay, what is property? Is it property? Can you sell it, give it, use it, destroy it, affix value to it? Then it might be. Property rights can be looked at as a bundle of sticks, and the state generally defines what the property right is, and the feds might limit it. But the bundle of sticks rights are possession, use, the right to exclude, to alienate, and to destroy. A property interest provides legal protection from interference by others and may be required for an assertion of rights. There's lots of theories of ownership. Economic, make the highest and best use of economic resources. There's fruits of your labor, or just labor. Occupation, effort involved justifies protection of these rights. Natural right is it's God-given. Social utility, maximum fulfillment of needs. Democratic, need to have redistribution. Economic theories, there's the tragedy of the commons, which comes up a lot. A situation in a shared resource system where the individual users acting independently according to their own self-interest behave contrary to the common good of all users by depleting or spoiling that resource through collective action. The Coase theorem, under perfect competition, once government has assigned clearly defined property rights in a contested resource, and as long as the transaction costs are negligible, private parties that generate are affected by externalities and will negotiate voluntary agreements that lead to the socially optimal resource allocation and output regardless of how the property rights are assigned by the government. Torts, protections, and remedies. We have the tort of conversion. It's a strict liability tort. You can't convert, but you can't convert what isn't owned. So this is the Moore case. Exercise dominion. So who is exercising dominion and control over the personal property that belongs to and is owned by another? That's conversion. Exercise dominion and control over the personal property that belongs to another. There's also trespass. The elements are wrongful without permission. Can be a mistake, doesn't matter. Entry upon land owned by another. The remedies are ejectment or a statute of limitations on trespass may result in adverse possession. But there's more for that one. Protections. We have the right to due process. Due process clause says the federal government cannot deprive a person or property without the due process of law, generally require notice and a hearing before taking action that would deprive a citizen of their property. We have a takings clause, and that is the right to compensation for government taking a private property for public use. And then the types of protection, we have rules. They provide a minimum, no discretion in its application once the enforcing authority has determined the underlying facts have triggered the rule. And then we have standards, contain a list of factors the authorities must weigh and balance to determine whether a person's behavior is lawful or unlawful. And then we have the right to publicity. The right to publicity, I got really distracted for a second. The right to publicity is the right of a person to own and control the commercial use of his or her identity. Publicity refers to commercial use, while the right to privacy is the right to be left alone, and that expires upon death, where publicity does not. Rights secured through the right of publicity, the non-economic ones are incentive for creativity and achievement, and incentive to cultivate talent. That improves society. And the economic are securing the fruits of your own labor, safeguarding natural rights, preventing unjust enrichment, and averting emotional harm. So we have some remedies. Common law civil remedies for real property for unlawful possession are ejectment, and for trespass we have damages. And then personal property we have rep levin, which means to give it back, reptile. Give it back, reptile. Rep 11, give it back, reptile. And then we have trover, and that's damages, so you pay me. Grover pays Trover. Red Rover, let Trover come over. Pay me. Come at me, pay me. Same thing. And then there are equitable remedies, and equitable remedies are injunction, rescission, reformation, removal of clouds on title, and specific performance. Then we have property concepts. There's legal title when a person is the legal owner of property. We'll learn later that this makes it personal property, not real property. Anyway, statute of frauds. That says that there must be a writing for anything, that a lease that is more than 1 year, a sales contract for sale of land, or a creation or transfer of an interest in land deed must be in writing. Chain of title is the transfer of property from one person to another. Color of title is possession is based on a written document that on its face appears to grant valid title, but in fact it does not. A bona fide purchaser is when a buyer purchases property in good faith and without notice of a competing claim of superior ownership. Okay. Possession, the physical act of control over an object. The intent to control the object or to exclude possession of the object by others, and determines the superior legal right. Type of property, real property. Elements, land, which cannot be destroyed. Affixed to land is unique. Those are elements of real property. Elements is probably the wrong word. These are factors, because land is real property. And in an elements test, you have to fulfill them all. So these are factors. Land, which cannot be destroyed, something affixed to land, or is unique. Sorry. Attaining ownership of real property. You can convey a legal title via a deed, or you can acquire a title via adverse possession. Personal property. Tangible can be chattels. These are physical things, or intangible, money, stocks, insurance. How to acquire possession? A blurred question between law and fact of property. Voluntary transfer. Gifts of personal property. Donor has donative intent. So the donor must give now, not in the future. Presently, operational right. Possession might come later. And it must be irrevocable. So we must be given now and irrevocably. Acts of delivery. Common law manual delivery. Hand it over. Modern view delivery is practicable. So what's reasonable? Constructive, some districts providing sole means of access to a gift. So safety deposit box, 1 key. Symbolic, receives a document or a symbol of gifted item. Donnie must accept, but there is a presumption of acceptance, especially with gifts of value. A gift can only be given in life, otherwise it has to go to a will. Dispute, has the donor relinquished dominion and control over the gifted property? Bailments. Bailments of personal property. A bailment, the rightful possession of personal property by one who is not the true owner. A bailee is one who holds the property for a certain purpose with the understanding that when the purpose is accomplished, the property will be returned to the bailor. To create a bailment, there must be an express or implied agreement to create a bailment, a delivery of physical control, and the intent on the part of the bailee to exercise that control. Okay. Classification of bailment, negligence actions. For sole benefit of bailee, only slight negligence needed. So if I give you something and you are holding it only for my purpose, then wrong way. If I give you something because you need it, then, and something happens to it, I only need to prove slight negligence. But if I give it to you and it's only for my benefit, then gross negligence because you're doing me a solid. If it's for mutual benefit, then it's ordinary. So it's a continuum. The presumption is on Bailey negligence or conversion. Special issues, majority jurisdictions. Signs with this exculpatory language, the courts find void. We take no responsibility for lost or damaged items. No. Property can be obtained through eminent domain. We're switching gears. Property can be obtained through creation. And the creation brings us into the intellectual property realm. So property rights based on creation. And intellectual property is intangible property. The Constitution grants protection for copyrights and patents. Sorry. This thing is sitting on my legs and I keep moving. Because I have to keep moving. Constitution grants protection for copyrights and patents. IP includes patents, which are inventions. The legislation says that Section 101 of 1952 Patent Act must be manufactured. 2013 American Inventors Act gives priority to the... Okay, so it's the priority of the invention was in the early days given to manufacturing, but now it's given to the first inventor on file. Things that are not patentable are laws of nature, natural phenomenon, abstract ideas. And a patent protection is 20 years plus 5. Copyright protects a form of expression of an idea, gives right to an artist to control the reproduction of their intellectual creation after distribution, protects the rights of authors and the public interest, rewards authors for social contributions, gives author economic market reward, authors have natural right, it fosters growth, unique symbols, pictures, and words sellers use to distinguish products from their competitors, not designed to reward creator, awarded to the first to use... Oh, wait, what? We just jumped to trade dress. And I don't know why. So now we're going to go to trademarks. I don't know why there's no caption here. Sorry. Trademarks are unique symbols, pictures, or words sellers use to distinguish products from their competitors. They're not designed to reward the creator. They're designed to protect the product. They are awarded to the first to use a distinctive mark in commerce. They protect goodwill, and they're good until they're abandoned or it becomes generic. There's also trade dress, and that's the total image of a product, like a Coca-Cola bottle. There's also a service mark to identify a service. The Lantham Act allows for mark use descriptively and in good faith. Dilution of trademark. So it can be argued that there's been dilution if the senior... But in order... so a senior can sue someone for dilution of trademark, but the senior must be famous, distinctive, junior must be used commercially, junior must have begun after senior was famous, and must cause dilution of distinct equality. Then, it's intellectual property. You can also obtain property through adverse possession, and we're going to do this real fast because I feel I know this well. The elements of adverse possession are canoe with the paddle that looks like an H. C, continuous pattern of occupation like that of a true owner. B, actual acts of occupations like that of a true owner. C, notorious and open. These are acts of possession sufficient to put the true owner on notice. E, exclusive possession, exclusive of the owner and other strangers. And then your F is hostile, and these are different jurisdictions. So in a good faith jurisdiction, no, we're going to talk majority first. And a majority is objective. It evaluates hostility based on actual acts of occupation done without permission. So we're only saying done without permission. But in a good faith jurisdiction, they look at the subjective intent of the possessor. So they're saying if it's good faith, the possessor thinks they own it, and they just don't know. But if it's bad faith, they're saying you're a pirate. You know that they don't know. You know? Okay, so statute of limitations is different for every place, but you can include things like tacking. That looks at the possessor and requires privity or voluntary transfer of possession. There's also inverse tacking, and this is if the land changes ownership. Doesn't matter, you're still looking at the possessor. If the possessor hasn't changed, their statute of limitations is still running. Tolling, though, is looking at the possessor, and you're going to get a statute in an exam of what this means, but basically if there's a disability, which can include being a minor, insanity, imprisonment, military service, disability must present at the start time of the adverse possession in order to work. If it happens in the middle, it doesn't. If the owner has an adverse possessor on their land and they die and they leave it to their 8-year-old child doesn't get to toll because the adverse possessor was already there. So disabilities cannot be tacked. So if you're a minor and then you're insane when you don't get both. California has a 20-year statute on this, so you get 20 years and then you're 5 years for a statute of limitation after it runs out. Color of title limitations. You can't have color of title if owner is on part of the land. Lots must be contiguous, and they have to be owned by the same person. Okay. So if you have a color of title for multiple lots, they must be owned by the same person, they must be contiguous, and if someone lives on there, you're not going to get it. Claim. If you win, if you do an action for quiet title and you win, you get a brand new title that's dated to the start of the possession. That's it. And if you lose, probably going to be ejected pretty darn quick. What does cause of action start? This is for adverse possession of personal property, and there's two ways. One is the discovery rule, when you discover who has it, did they discover you have it, and then there's the replevin rule, which reptile give it back, and that means when you demand it back. Inheriting, transfer after death. Probate means you'll go to court. Uniform probate code, relaxation of some will formalities. Litigation, if multiple wills in a whole or part. There can be subsequent wills or codicil. Physical acts of tearing up work for a will. They do not work for a deed, but they work for a will. And operations of law, like a divorce, will change them. Testamentary is will, and testate is no will. And if there's no will, you'll go for the rule of primogeniture, which is like hierarchy of who gets what. statute of distribution from foreign basis of today's law. Okay. Then there's will substitutes, and these can be life insurance, pension accounts, revocable inter vivos gifts, bank, brokerage, mutual fund accounts. All right. Now we're going to talk about fee simple estates. My formatting got messed up. Not sure how. I don't think I touched it. Whatever. Okay, so fee simple is from an English law meaning absolute ownership of the land. There's also life estates, ownership that ceases upon the death of the current owner and reverts back to the original owner is the life estate. Present and future interests, estates, is an interest in land which is or may become possessory. Is ownership measured in terms of duration. Okay. Freehold and non-freehold estates. Rule of perpetuities. Someone who is alive when the perpetuity period begins and we are sure the future interest will vest and not during their lifetime or within 21 years of death. Rule of perpetuities only applies to executory interests, always springing or shifting, contingent remainders, even alternatives. O always has a reversion in a contingent remainder, and a vested remainder is subject to open. Those are the only thing the rule of perpetuities work for. Executory interest, contingent remainders, vested remainders subject to open. It does not apply to regular vested remainders, an interest to a grantor, or the possibility of a reverter. Right of reentry, reversion, or life estates or tendencies. So the only time the rule of perpetuities is executory interest, contingent remainders, vested remainders subject to open. Doctrine of destructibility. A contingent remainder must vest on or before the termination of the preceding estate. If it does not, it is destroyed. Okay, and I have this chart. You're not going to be able to read it. If you want me to send it to you, put a note in the comments, I guess. I found it very helpful. It basically just is like a grid of fee simple absolute, fee simple determinable, fee simple subject to conditions subsequent, fee simple subject to executory and limitation, shifting and springing, fee tail, life estate, term of years, periodic, and then there's tendencies, term of years, periodic, at will, and sufferance, and then like the language to make them, what their future corresponding interest is, who their third party is credited to, and how to terminate it. Message me in the comments if you want it. Okay. The doctrine of waste means that unreasonable use or change of property by owner of a present estate which reduces the value of or otherwise impacts the value of the future estate. So these types of waste are ameliorative, which is demolishing or a substantial change, voluntary, which is decrease the value of a fee estate, permissive, which is a failure to protect. Majority views, tenants can demolish or make extensive alterations or replace structures in order to enable reasonable use of property, provided such change does not diminish value of reversion or remainder. I need a blank because it's 65 in California. You're so patient. Thank you so much. My beautiful audience, which may just be of Linda. Okay. Love you, girl. Anyway, okay, so if people don't like it, what you're doing to the land, they can ask for a partition. And a partition in kind is a physical partition. I'm not sure this is the best place for it to be, but partition is going to carry us through for the next while. So, and there is a partition by sale, which means you sell and you split the money. This is what happened with the Popoff case with the baseball. If a sale is ordered, how does the court divide sale proceeds between life, tenant, and remainder? I really hope we don't have any questions like this. It could be a judicially created trust, or they could distribute sale proceeds immediately. Time value of money. Right to receive a sum of money in the future is not worth as much as the right to receive the same amount today. Alienation. Let me see if there's a good place to stop. Yeah, okay. Waste, partition, alienation. Direct restraints on alienation, freedom of alienation, disabling restraints are normally ineffective. Forfeiture restraint may not be valid if time frame is unlimited in fee simple. Promissory restraint may not be valid if unlimited and imposed on fee estate, but is okay in leasehold. I don't have any idea what we're talking about. And I don't know where there it is, my pen. I'm going to say, why is this here? Courts are more likely to allow restraint if it's limited in time, not restraining in fee simple, or there is a legitimate reason. And that is where I'm going to stop for here for the intro. We're going to talk about more ways that you can get property, because we are at number 6 in the list. Okay.